Okay, so good afternoon. I'm Karen Catuno, and I'd like to welcome you to our first expert forum for 2022. Ricabor is the only realtor board in Rhode Island that's dedicated to serving the needs of commercial real estate and appraisal practitioners. When you come to our meetings and our events, you're not going to hear anything about residential real estate. We are the no residential real estate zone. Because of what we do, our members, we believe, are among the top leaders in Rhode Island's commercial and appraisal industries. So this forum series is designed to bringing you in the experts that are going to help you sharpen your skills, answer your questions, and broaden your knowledge base to the next level. So to those of you that are members of Ricabor, thank you so much for being here. To any non-members, if you are considering at all any aspect of commercial real estate, you might want to consider joining Ricabor as a secondary board member. We bring a lot to the table and we'd love to have you join us. When you join us, you get the opportunity to mingle with what I believe are some of the best people in Rhode Island doing this work. Jack, our sponsors, we have a number of sponsors at Ricabor, and we'd like to extend our thanks to our sponsors. Jack, yep, there we go, we have them. Cornerstone Commercial Capital, Mo's Moving, Sage Environmental, Venus Title and Escrow, and Sayer, Regan, and Thayer, the people who are going to be talking today, answering your questions. And while we are all here, I would like to put out a call to action for RPAC. If you haven't made your contribution to RPAC, consider pulling out your checkbook after we finish today and write your check, because that's very, very important. They do important work and they need all of us to contribute to continue that important work for our industry. So I'd also like to shout out Patty Flowers. She was a prior presenter, IPX 1031 Exchange. We're hoping we'll have her back for another session so that she can answer all of your questions on 1031 exchanges. So now we're going to go on to the program. Today we have had a change to our program. Our speaker is going to be Adam Thayer of Sayer, Regan, and Thayer. Unfortunately, Peter Regan cannot be here. He had a death in his family. So we wanted to extend Ricabor wants to extend his condolences to Peter and his family and to his law firm family also for their loss. But Adam is here. Adam focuses on the transactional aspects of commercial real estate primarily, but also handles some litigation type issues. He has a pretty big volume of commercial closings and he represents both lenders and borrowers. So I'm going to be turning this over to Adam in a minute. Just one kind of procedural thing. We're encouraging interaction. We don't want to wait until the end of the program to have you ask your questions. We'd like them to be in context to what is being talked about at the current time. So if you do have a question, click on your chat button. I will be monitoring it and I'd be happy to read your questions so that, remember, the questions you ask are probably the questions other people are thinking of. So let's all participate on this. So at this point, I'm going to turn the floor over to Adam and we will start. Thank you.
Okay, thank you very much. Thank you everyone for having me. As Karen said, unfortunately, Peter's father passed away yesterday. Elderly man passed away peacefully. So, obviously very sad, but, he had a great life and we're all going to be there for Peter. So Peter knew that I'm smarter than him anyway. So you wanted to have me, if you're going to lose one of us, so, you didn't want to lose me. So you got me here and I'm going to do my best to make this lively and somewhat entertaining. And I got my little list of questions that I talked about with Steve. So I teach some classes with RIAR. I do a lot of these Zoom talks. And so I know it can be kind of weird in terms of people jumping in, but like Karen said, type questions in the chat. I'm more than happy to go through it. no question is a stupid one unless it is who is the greatest quarterback of all time. Obviously, Tom Brady. So with all that having been said, Steve, I'm just going to start going through some of the stuff that we talked about. And if you want to interrupt and ask follow-up questions, or if anybody has any follow-up questions, I will do my best to answer those as well. So one of the first things that Steve had primed me for was one of the, I guess, kind of the impetus of this whole talk was what's going on right now? What are we seeing? And, to what extent is that impacted due to COVID and everything else that's going along with that, with socially distanced closings and the supply chain and everything else that's kind of, trickled down from that. And so the first thing that Steve had asked me to talk about would be the effect on the timing of closings and just the logistics and stuff like that. So I think the short answer is that everything takes longer. So anybody who's been doing any sort of business, I think is probably seeing that. When we do a lot of our, in particular, SBA finance closings with the 504 loans, we're looking at closings with roughly 60 days for due diligence periods. I mean, this is assuming that there's no permitting or not vacant land that's going to be developed. This would just be a normal, existing structure that you might be purchasing, an acquisition, with roughly 60-day financing, 60-day due diligence, however you want to phrase that, and a 90-day close. And I think that that's kind of what most people are comfortable with. We're used to seeing those kind of time frames involved. Maybe you have a shorter due diligence contingency. Maybe it's an existing tenant buying a property that gets shortened, but roughly you're talking about those kind of time frames. And as COVID has kind of developed, and in particular with Delta and then Omicron and the supply chain and all these different banks being understaffed or having people out, or the SBA being understaffed, having people out, I start talking to these loan officers who don't want to get in trouble with their referral sources, a lot of the brokers that refer them business, but they'll say to me, particularly when I'm on the borrower side, they'll say, "Hey, Adam, this loan isn't going to get approved. We can't close this in 90 days. It's going to be a 100-day close. It's going to be a 110-day close," which can be a huge deal, especially if you have time is of the essence in a contract. So I know the custom very frequently, particularly on residential, but also sometimes on commercial in Rhode Island, is to not have time is of the essence in there, which gives us a reasonable period of time to get the deal done. If we have a 90-day close in there and it takes 100 days, the buyer or the seller, I guess, if the seller caused a delay, doesn't have to worry about being in default. But you have to be very cognizant, especially if you as a broker are doing some of your own contracts, or if you have someone who might be coming from Massachusetts, which is usually always a times of the essence state, or if you just got somebody that always does times of the essence. Some people who only do commercial, that's just what they always do, is times of the essence. You're gonna be much more cognizant of those deadlines. So I think that at a minimum, these deals are getting extended out. Some of them, I know Steve and I had one that was supposed to close in the middle of the fall. It ended up trying to close in December. Then the client got COVID and it got kicked out another 10 days, almost 2 weeks. So that kind of stuff is happening on a regular basis. So I think we got to factor that in terms of timing. Obviously less so when it comes to the non-finance deals. But then to take that to the next level are the deals that involve any sort of permitting or approval process. If you're having to go to any of these towns, I mean, one of the things that Peter told me to say was, is there anybody here on this call who the last 2 or 3 years haven't been the 2 or 3 busiest years of their career? I mean, there might be somebody, but I would doubt it. It's not only is our end of the real estate spectrum extraordinarily busy, maybe all time busy, but a lot of these municipal or government bodies that we have to go before are also at that same level. And they might be dealing with staffing issues like a lot of these lenders are. And so, what Peter was just telling me, like, for example, they filed for a zoning application in Newport. And what we're advising our clients right now is if you're in a municipality where there's a high level of development going on, which even in a town like Newport that's fairly developed, there's so many people putting on rooftop decks or expanding outdoor seating or something like that. You're talking about 4 months just to get maybe like a formal zoning decision. So right there, I mean, we're not even talking about reinventing the wheel or doing anything that might be contested or overly complex or involve multiple phases of planning, then zoning, then back to planning or zoning or something like that. Just your plain vanilla, we need a zoning decision. that might even have a little bit of hair on it, we're talking 4 months. So that's something, again, that we've got to build into these contracts, especially if time is of the essence, because the last thing you want to do, I had a deal where I was borrower's counsel, I was, sorry, bank counsel and SBA counsel on a large land development. I did all of the loan documents because I got to get all that stuff done ahead of time. And then the borrower's attorney didn't realize they had time is of the essence in the deal. And I saw it in the purchase and sales agreement, and the entire deal died. It was like $5 million deal. And, you know, everyone was very upset, and it was all because, you know, the time it was, and this was a development of vacant land. So something that everybody really needs to be cognizant of. Another thing that Steve asked me to highlight on was, you know, what does the closing of tomorrow look like? Which, you know, almost sounds like the old, like Walt Disney, you know, Epcot thing. What does the closing of tomorrow look like? Probably a lot like they do right now, unfortunately. You know, I always joke with people when I do my closings, I have my little spiel. Gretel, you're going to hear my spiel next month when I see you. I didn't realize you were a realtor. But what I have my whole spiel. Okay. And prior to March or April of 2020, we'd have buyers, sellers, realtors, loan officer, maybe a parent or a friend. We'd have 10 people in a conference room. We'd have to bring in extra chairs sometimes. Obviously, that is not the case anymore. I did closings for a year in the parking lot of my office on the hood of cars, pre-vaccine, and we still all got COVID anyway. Now that we're kind of getting back into this rhythm of living with COVID, but we're vaccinated, and you know, there aren't these like rampant outbreaks, you know, hopefully. I think that we're going to get into this rhythm of sellers sign with their lawyer, FedEx the documents to the buyer's lawyer, or courier them. Buyers are just signing with their attorney, with maybe the bank's counsel there if it's financed. I think that's the way it's going to go. I know everybody, when COVID first hit, I was kind of creating these email threads because it was, I'm sure your office has dealt with it. It was chaos. And I created these email threads with a lot of the realtor partners that I work with, but then I had another one with all the lawyers, so that we could all get on the same page, because I didn't want to have a situation where I was enacting these closing protocols and then you go, well, hey, Ed Avila's office is not doing that. They said I can do this. Or Chris Rhodes said he's going to do that. You know, I think we wanted a united front as to this is what we think is appropriate. And so we're not kind of like, oh, well, you know, stepping on each other's toes. And part of that was this sort of promise of remote notarization being the next phase. And it reminds me of like the flying car, where like it's always 1 year away. You know, it's always around the corner, but it never actually happens. That's what ended up happening with remote notarization. I mean, we did the last 2 years, 2,000 closings. I think I had 4 documents in all 2,000 closings that might have been e-notarized, and they were like ticky-tack things we didn't even care about. And people always look at me, you know, every time people come into a closing, they'll see one of these, you know, closing binders like this, and they'll say to me, when can I sign this? When is this all going to go away? And the problem is, I would love for it to go away, but the town halls or registries of deeds have a certain requirements for their documents. The bank has a certain requirement for their documents. The title companies have and everybody has these like whack-a-mole requirements. The only thing everyone agrees on is they will take wet, signed, notarized documents. So if I have to have you come in and at least sign one, then what the hell, you might as well sign all of them, as opposed to doing it piecemeal. So that remote online notarization, I don't think is really going to impact us on any sort of meaningful scale. What I did see change was if anybody's had to file 71.3s, the Rhode Island election based on gain for non-residents, Providence Division of Taxation for years told us it was impossible to electronically file these. Can't do it, can't even think about it, never going to happen. Guess what? COVID hit, magically it was possible. All of a sudden, boom, we can electronically file them. And it was one of those positive unintended consequences of the pandemic that similarly, Massachusetts has been doing e-filing, e-recording with the registries of deeds for literally years. Rhode Island did not have it anywhere. Why? Because we're always a day late and a dollar short when it comes to Massachusetts. Now we've got a handful of municipalities that are on board with the online recording, which has drastically simplified how some of this stuff has to go. So I think we're moving in the right direction towards dragging the real estate profession into the 21st century, but it's 2022. I think Little Compton's land evidence records came online 3 years ago. My mom thought we were going to have self-driving cars on the road. And I used to always tell her, I said, when Little Compton has their land evidence records online, then maybe we can have robots on the road. So I know we want to get there, but it's the regulation isn't keeping up with the speed at which that we're going. So unfortunately, I think what you're experiencing right now is probably going to be the way it's going to go for a little while here. You sign with your own attorneys. Realtors probably aren't going to be attending a lot of the actual physical closings, with it mostly just being maybe banks counsel and borrowers counsel and the borrowers at the actual closing itself. The next one, language in purchase and sales agreements and leases. The whole thing that we're dealing with here is what we call force majeure, or like act of God, whatever you want to call it, that the pandemic was something that no one foresaw, that had these unbelievable impacts that either can make deals or leases or something like that either impossible, or if not impossible, so drastically altered due to the reality of the situation that it was no longer the intent of the parties. And in real estate purchase and sales agreements, I think that you have to be really careful with the phrase time is of the essence, which we've kind of already alluded to, because it gives such a hard deadline. The deal that Steve and I had, it was already so delayed due to like SBA and bank financing stuff. And we finally got the deal scheduled for a Monday. I was in my basement at my house on a Sunday, and I saw an email from the client that he had just tested positive. This was like right before Christmas, like just before the real peak of Omicron. And then I literally got on the phone. I had to call Chris Rhodes and Eric Chappelle, who are the two other lawyers, and let them know we're going to have to delay everything. And so if we had time is of the essence, that could have caused a major problem there. So I think we got to be really cognizant of the use of that phrase. And if you're dealing with somebody who is, that's just the way they do business, is the use of that phrase, is we got to have a heart to heart as to why it might not be appropriate, or why we might need to carve out some sort of an exception for, COVID related delay. Similarly, new construction. If anybody's been involved in any sort of new construction lately, I don't know if you've heard, but things cost like 10 times what they used to cost. Okay. They had a whole thing with Mission Burger in Middletown. They posted something on their Instagram that showed, this was like probably 6 months ago. It showed what certain things cost them now versus what they cost them 6 months ago and 12 months ago. And it was like just the little box for the fries to what a napkin costs and everything, and just trying to ask people to bear with them because of how expensive it had become and how tight their profit margins had become. This is a huge issue right now in the new construction game. And so I was just working on a contract literally yesterday for one. And we had time is of the essence in there because we got a very long runway on this project, but then we carved out, but we can have reasonable delays for COVID related supply chain issues, which the realtor called me and said, practically speaking, what does this time is of the essence actually mean now? I mean, we're in uncharted territory here, where I'm trying to do my best to set the expectation to everybody. Hey, dates matter. We want the dates met with as much as humanly possible. However, we're not monsters. We're not idiots. We realize that this craziness is going on, and we will allow for reasonable delays based on this subset of circumstances. Peter in my office, one of the things he deals with a lot of builders, is, I don't know if you've ever seen this in contracts, where if a contractor goes beyond a certain date, money starts coming off the contract price. And sometimes vice versa. If they complete it early, they get a little bit more money. And that's now becoming less common because it's so much harder for people to hit these dates. And then also builders being more reticent to do flat fee, guarantee, like we're going to do it for just this flat fee for the dollar of the project price, because the ability of and the tendency of raw materials to just wildly fluctuate in value right now. So those things could be happening. In the leasing game, we did a bunch of legal research before this talk to try and see if any of these clauses that had been in purchase and sales agreements, but even more so in leases, for basically force majeure, act of God, something crazy happens, the building blows down, there's a hurricane, there's a pandemic. And there are many cases in active litigation right now. Thus far, we couldn't find any reported decisions by the Superior Court that had actively decided one of these ones in the recent memory regarding this impact now due to COVID. It sounds like in the next 6 months we're going to start getting these. But talking to Peter, because this is really his area, his opinion on this is that it's really going to come down to the way those clauses were drafted. And some of them might have included the word pandemic. Some of them might have included some phrasing that could have been covered by this, but it's really going to come down to the drafting of the actual provisions, which obviously will be changed forever now, because now everyone will be considering this potential possibility. Changing language in loan documents. I really haven't seen that this much. It's a great question. I just haven't seen it. And that doesn't mean it doesn't exist. And I know real estate residential is a 4-letter word in this group, but that's really the only area that I'm seeing it thus far, is that on my residential closing packages, a lot of specific COVID addenda or amendments that where a borrower has to represent they haven't lost their job or had any other loss of a source of income that could prevent them or impair their ability to repay the loan. On the commercial side, at least when I'm representing banks and a lot of the other attorneys that I know that represent the banks, the usual suspects, Ed Avila, Jim Icoy, Chris Rhodes, these folks, Richard Hentz, all these folks, we all kind of have our flavors of loan packages, but they're all kind of similar. And a lot of the documents that we already have in there, such as like a certificate of no adverse change, where a borrower is representing that they've had no material changes to their financial position since they applied for the loan, are kind of all encompassing. We'll kind of include this and this COVID stuff. And I haven't really seen a bank specifically ask for anything additional thus far. The only time I've really seen it has been on the SBA end. If anybody here has been involved in 504 transactions, the SBA, prior to the funding of the deal, the whoever the loan officer is at the CDC, which is the entity that underwrites the 504 loan at the local level, they'll issue what's called a no adverse change 327 action, which is basically them advising the SBA headquarters that the borrower is still able to pay back the loan. So they've now created a new one of those just for the COVID scenario here. But other than that, I haven't really seen major changes. Karen, you're muted.
They generate, local department generates this paper saying no adverse change. And
sorry, can you start that question again? The very beginning of your comment was cut off.
Sure. Sorry about that. You were just talking about the SBA loans, and you were saying there's this process now where somebody is generating some document that says there's no adverse change.
Yep.
Is the person creating that document going back to the individual applying for the loan and asking for additional documentation? And is that delaying any of this process?
Okay, great question. So anybody who's doing any of these 504s, you're probably seeing Ocean State Business Development Authority, Bay Colony, Seed, right? These are some of the bigger players locally. The person that is usually your primary point of contact there is going to be going back and they should be. I mean, I'm not directly involved in this process, but from what the emails I'm CC'd on in my review of the documents that I'm getting, that person, your primary contact, is staying, guiding that borrower through the process. As they get kind of towards the end, they are continuing getting updated financials from this borrower, or they should be, that are then showing that, hey, we haven't had a massive loss of income. No one's lost their job. There's been no sort of, updated executive orders that are going to impact the proposed use of this property. So, and then that gets submitted to the SBA, and then gets approved by the local district council. And that's what, like when I'm representing the SBA, I need a copy of that to get the loan ultimately funded. So I can't speak to every CDC, the local SBA offices. I only work with one of them on a SBA representation side, but that is how they handle that process. So overview of the court procedures, litigation and eviction. So that's another next one that Steve had. So this isn't really my area, but what ends up happening is my area feeds that area. So I see it to a certain extent before it goes full blown litigation. When COVID first hit, if any of you have a lawyer in the family, then what you may not know is that we hate family gatherings, because what ends up happening is, just like if you have somebody who works on computers in your family, anytime they go to Christmas or Thanksgiving, people just download their computer questions to them. That's what happens with lawyers. Everyone just assumes you know everything about every area of the law at every family event. And you end up doing stuff for family members constantly. So whenever a cousin of mine gets caught with like an open container at URI or gets a DUI, guess who they call? The guy who doesn't do any of that area of law. And so I had a cousin who got a DUI. He was totally innocent, by the way, totally 100% innocent, completely wrongfully arrested. Down at URI, that was the summer of 2020. And at the time, I had to talk to my friends who actually do this area of law. They were basically only hearing DUIs, domestics, and murders. That was it. Forget anything else criminal, let alone civil. So what it created was this just tsunami of backlog cases that have taken forever to start like winding themselves out and getting rid of that backlog. And the problem that we're still seeing is that there are a lot of criminal cases, particularly that need jury trials, that still have not gotten to that stage of the game yet. And as a result, they have to take precedence over the civil trials because you have constitutional rights to a speedy trial when you're charged criminally. So this isn't to say that civil has come to a dead stop, but it was slow to begin with. And now it's especially slow due to the fact that we've got still these criminal cases ahead of it. Peter was just telling me he filed something for a motion in Newport the other day. It's going to get heard in June. So, when I talk to clients before it gets down the hall to Peter's office, I usually tell them there's the legal reality and the practical reality. And so people will say, well, what are you talking about? Well, let's say you've got a landlord-tenant case where the landlord has been screwed out of $2,000 and the tenant has just taken off. I can tell the landlord, listen, you've got the greatest case I've ever heard of all time, but it's going to cost you $5,000 to go after $2,000. And I guarantee we're never going to collect a penny from this person. The juice is not worth the squeeze. If you're working with a lawyer who doesn't have that sort of conversation with you before they take a litigation case, you need to get a new lawyer, because that is just basic fiduciary obligation that I know a lot of times it's not going to explain to clients, because what ends up happening is the lawyer is the only one that gets rich on those cases. So, and that extends up and down the ladder. There are some times where it could be a $10,000 case where it's going to cost $30,000 to go after it, and the likelihood of recovery or victory is low. So the process has been drastically dragged out. And as a result, it can become even more expensive and time consuming. And so you and whatever law firm you're working with need to have heart-to-hearts with clients that, even though they might be getting totally taken advantage of or screwed or whatever, because they're on the right side of the law, the reality of the situation might still not lend itself to going full boat in litigation. I mean, practically speaking, I used to get involved in this stuff earlier on in my career. This is why I liked arbitration. You could get a neutral third party in front of people and try and let them see the light of day as to what side of the fence they were on with a dispute, without having to go months and months and years into a case. Yes, Karen.
All right, I have to unmute myself. So based upon what you're saying, are you recommending or suggesting that with commercial leases that there be a mandatory arbitration or a binding arbitration clause in the leases that our clients are looking at in the commercial setting, so that you can bypass the court system or not?
That's a great question. If it was me, I would like that. I mean, again, I'm not a litigator. Okay, so take what I'm saying with a grain of salt, because this is my personal opinion. Some litigators, they just love to get into it and roll around in the mud and scream and yell on the phone. And I'm a transactional guy. You want to close the deal, they want to close the deal. What do we need to do to make it happen? Okay, that is how I am. So when the alternative dispute resolution, mediation, and arbitration, I love it, because you'd go down to the courthouse and they'd have the mediation clinic from Roger Williams there to try and help people hug it out in the back room. And if that couldn't happen, we get some quasi-retired lawyer who would sit as an arbitrator who'd come in and give it to you straight, and either be binding or non-binding. And I liked that because you can get into an echo chamber of your side of the case where everyone just feels like they've been wronged, but the other side feels like they've been wronged. And next thing you know, it's 2 or 3 years later, and the only person who got rich on this case is the lawyer. I don't know if making it arbitration mandatory is necessarily going to be palatable to all people. And especially if you ever have a litigating attorney who finds their way into a transaction, I mean, it's immediately apparent by the emails you get, because they go 0 to 60 a lot of the time right out of the gate. But so they might not be as comfortable with that, because they might be more comfortable in the courtroom. They have a good rapport. They know the way everything goes in whatever court will be hearing that case. So I personally would like that. I don't know if everybody would like it, but I'm always right. So take what I'm saying. What I said is correct. To hell with what everybody else thinks. Advances in technology, digital signing, deed recordings, online research. So like I said, we did it. Little Compton land evidence records are online, believe it or not. I think all of Rhode Island is now. And then Rhode Island has a lot of the towns are now doing e-recording, which again is just huge. Mass was already there. Connecticut is getting there, is there largely too. There are multiple services. I kind of have to do a whack-a-mole a little bit with what companies I'm signed up for. Some do Rhode Island, some do Connecticut, some do Mass, some do Rhode Island, but not Tiverton. We're still in the infancy stage. It's like if anybody got a Roku right out of the gate, and half the time the apps didn't work. Like, we're all happy the technology is like coming, but like I don't feel like it's fully integrated and fully there yet. The digital signings, I'm a huge fan of them, particularly when we've got people all over the place. It's been very difficult getting them to be more accepted. Like the Division of Taxation, for example, still will not take digital signings on the 71.3s. Even though I think they should, but they don't listen to me. I think we're getting there. I don't think that we're there yet. Maybe in the next 5 years, but again, it seems like one of those things that it took literally an act of God. It took a generational pandemic to be allowed to e-record deeds in Providence when Fall River had been e-recording deeds for almost a decade. I don't know why that's the case. I don't know why the disparity between Mass and Rhode Island. I don't know why it was like that, but that was just the reality of the situation. So I think, unfortunately, it takes these sort of disruptor events to get the ball moving, and we're definitely not there yet. Last one, how brokers and appraisers can better work with the legal community. That is a great question, Steve. I think just the communication is so huge. When I went to law school, when I describe it to people is like when you're a kid and you just assume adults know what they're doing all the time. And then you become an adult and you realize that no one knows what they're doing and they're all just kind of faking it. Well, when you're like a baby lawyer, you're like, oh, I can't wait to get out of law school and know what I'm doing. And then you get out and you meet all these lawyers and you're like, wow, that guy has no idea what he's doing. And listen, I'm always learning. I know a lot of us are always learning, and hopefully that's why a lot of you are listening to me ramble for an hour here. Hopefully you might learn something. But if I've learned anything in the 10 years that I've been out of law school, it's as long as I am responsive to people, I'm competent, and if I make a mistake, I own it, I will have more business than I can possibly handle. I make mistakes all the time. I learn new things all the time and have to ask questions and have to ask other lawyers who thankfully, hashtag Chris Rhodes, hashtag Richard Hentz, all these guys who have, and gals, plenty of women too, who have been awesome to helping me learn, particularly the commercial world, which is much less cookie cutter than residential. But the number one thing has been being responsive. And if I make a mistake, own it. And it's very difficult. I don't mean to be ageist, but the responsiveness spectrum can skew younger because people my age, unfortunately, grew up being prisoners of this thing, right? I hate this thing, but it's a reality of my job. And unfortunately now, and this is certainly true on the residential side, but I feel like it's becoming more and more so true on the commercial side, is that the need for immediate gratification is becoming worse and worse. And I'm not saying I don't want to inflict what I have to deal with on you. I'm sure many of you are already dealing with this, but I think being a united front and maintaining that open line of communication with the lawyer that you're working with is huge. You know, I don't want to be, you know, to speak ill of anybody, but like if you're working with somebody and they send you an email, an attorney, and they've got an AOL email address, they're probably not going to be texting with you on a Sunday. Okay. So, I mean, let's just like these little things, like, and again, I'm not saying that texting on a Sunday is appropriate because I hate it. My wife yells at me. It's supposed to be our time. But at the same time, that's just the way the business is going. And I don't know how to stop it. Unfortunately, I'm caught up in it too. But I think forming a united front with whatever law firm you're usually working with, whoever you decide to pick, it could be anybody in the world. And the loan officers that you're working with, I think that is just so by far the number one thing, because you go sometimes where I'll wake up in the morning and I'll have 30 text messages because heaven forbid I put my phone down at 7 o'clock at night. And then the whole next day, no one responds to a call or an email during normal business hours. Which, you know, client management is something that, you know, if Steve and I have a deal together, we're doing the client management together. We're working as a team, hopefully, as opposed to kind of, you know, working on our own separate islands. So that would be my 2 cents about that. Those are all of Steve's questions and comments. Hopefully that wasn't horrible. I'm happy to answer questions if there are any.
So I'll start.
Sure.
I'll start. So let's go back to the first subject that you talked about, which is what I'm hearing are pitfalls of having a times of the essence clause in commercial purchase and sale agreement, for example.
Yep.
And so is that something, all right, let me step back. You also told us that there have been no court decisions which have interpreted some of these outs that you may have from the times of the essence clause. So we're in an area of uncertainty. Would you recommend in a commercial transaction that the time of the essence clause be eliminated immediately and perhaps have a more expansive due diligence clause that addresses perhaps some of the delays that we might encounter because of COVID?
Yeah, so that's a great question, and it brings up something else that I neglected to mention, which I wanted to talk about. One thing that we're dealing with, it's huge, especially here in Southern New England, where we've got Connecticut and Massachusetts right there. You know, I know we're in Rhode Island and we're Rhode Islanders, right? But with Fall River's 2 seconds away, Stonington's 2 seconds away, right? But it's all right here. Is dealing with Rhode Island is largely uniform in how we handle things. You start going just 5 minutes down the road, you go to a different state or you travel within those states, it can change drastically. And so what people, particularly if they've been in the business for a longer period of time, they're used to what they're used to. And so you do a closing in North Tiverton, no time is of the essence. Everyone's fine with it. You do a closing in Fall River, time is of the essence. Everyone's fine with it. You try and do that same thing 5 minutes down the road, heads explode. Okay. Why? It's just a custom thing. And so I think it's getting people to just talk reasonably about what the situation is. Hey, I know this is mass and I know that you're used to time is of the essence on every deal, but this is the reality of the situation. I just had another deal. We were burned on this. We had somebody get COVID at the last minute. Can we have a reasonable force majeure COVID clause that maybe carves out an exception to the times of the essence in general? And I think it's just having human to human talk about this. And if you have somebody who's being ridiculous because ridiculousness happens, you know, call me. I'll be happy to talk to somebody about that. But where the areas that I think, and I talked about this at a Newburgh County Board of Realtors breakfast the other day, and I sounded like a psychopath, and people loved it because I think other people were thinking this stuff too. Is number one, when somebody makes a cash offer, and two, how that impacts time is of the essence, and also how it relates to COVID. So I just started doing Connecticut a couple years ago, and Connecticut, I'm going to hold this up. This is from one of the standard, again, this is residential, but I like this. This is from one of the standard Connecticut purchase and sales agreements. Right? Anybody can see that right at the top. I know it's kind of out of focus a little bit, but basically what it says is somebody buying the deal cash, no financing. Two, are they getting financing, but the deal is not contingent upon it? 3, it's financed and the deal is contingent upon it. Because what I'm seeing is, whether it's commercial or residential, right? We got a hot property. 5 buyers come to the table and give you 5 offers that are all within sniffing distance of each other. And they say to you, hey, Jack, which one of these deals should I take? They're all pretty close. And you go, well, this one doesn't have a financing contingency, so it's a cash deal, so we should take that one. Okay. And to a certain extent, you're right, it's one less contingency. But if your clients have a hard deadline, they're doing a 1031 exchange, or they're selling this property and buying another property, not a 1031 exchange, whatever it is, they've got another transaction that is time is of the essence and yours is not, meaning yours has wiggle room, that's a problem. And it's become a major problem for me on multiple deals where, as Bill Parcells said, you want me to cook the dinner, let me buy the groceries. Lots of times I get a person in sales agreement that I didn't do, and now I've got to figure out how to deal with this, and everyone's yelling at me because I can't force someone to close on time. Because what ends up happening is that cash buyer, they were full of it. They were always going to get a loan, but they knew it was a hot property, so they couldn't have a financing contingency in there. We're supposed to close, let's just say February 1st. Well, their lender is not going to be ready until February 15th. And because there's not time of the essence, we can't force them to close. But your buyer, or your seller rather, has to purchase another property with these funds in Florida that is time of the essence and needs to close February 10th. Now we're in major trouble. And so the intersection of, is a deal cash, is it not cash, with time is of the essence, what I've talked to people at RIAR about is, at least with respect to the residential forms, because I've done this on my commercial purchase and sales agreements that I use. I don't use the phrase mortgage contingency. I say financing. Okay, because financing could be a loan against this property, a loan against another property, a loan against business assets or retirement accounts, whatever. Because I think we need to get, the terminology is important here because it helps prime people's mind for what we're actually talking about.
So Adam, I have a
yes.
question here. Great question from Steve. And this is, I think we run into this all of the time. So he is saying contractually, when is a finance condition solved? Lots of banks give an approval, but have 15 conditions. When can a seller rely on a solid deal? And I think he means that your financing is approved. Fully
Hey, first of all, I
approved.
just want to thank you for forcing your 2 daughters to come here and listen to me for what has almost been an hour. I'm sure they're enjoying this. That is a great question. Okay. So when I first got out of law school, Mike Miller, Eileen Hatfield, and my dad taught a seminar at the DCYF building on Valley Road in Middletown. Okay. And they all wrote up the things that they would put into a contract if they represented a buyer or a seller to make it more buyer or seller friendly. And then I stole all of those. And now I use them against Mike Miller all the time. And it's hysterical. Okay. Because he's about as dry as a saltine cracker. Okay. He does not find it funny at all. And one of the things that they would put in there, again, to harken back a little bit to residential, is on the standard RIAR purchase and sales agreement. That one says once a commitment letter is delivered, the contingency is satisfied. So a lot of these residential lawyers came back and they said, whoa. If we're representing a buyer, we want to change that to say it's only satisfies that condition. The financing contingency is only satisfied with the commitment letter if it contains conditions that a buyer can reasonably meet. Like you don't lose your job before closing, right? Something like that. And so it's really going to depend on the language of that contingency. Now, I don't mean to throw other lawyers under the bus, but as we discussed, I'm the best one in the state. I think we can all agree. Okay. And so there are lots of lawyers. Sorry, I'm just trying to be funny. There are lots of lawyers out there, okay, who are not going to have, maybe they're not traditionally a commercial attorney, or they didn't do a ton of real estate, or they're just sort of busy and they're not having a crazy eye to detail here. And they're going to do a contingency here that's not going to have this level of protections. I think it's just like these force majeure clauses where you're going to say, what does it actually say? I would say that in the absence of some sort of qualifying language, like we just discussed, that it only satisfies the condition if it contains satisfies the contingency if it contains conditions that a borrower can reasonably meet, then the second they give it to you as the listing agent, that contingency is satisfied. Because normally it's a commitment for lending, right? And like people always occasionally I have people tell me, well, I want an unconditional commitment. I say to them, nothing in the world is unconditional. My wife doesn't love me unconditionally, okay? A condition of her love is that I don't mess around, okay? Her love is conditioned upon me being a good guy. If I can't get unconditional love, you're not getting an unconditional loan from a bank, okay? It's just not happening. You can't lose your job. You got to have satisfy one of these COVID attestations that you're still able to pay back the loan, all that kind of stuff. So every loan commitment is going to contain conditions. So that's my long way of saying I think it kind of depends on how that's drafted. But in the absence of any qualifying language, I think once you get it, it's satisfied.
All right, do we have any other questions? Please hit your chat button and give us some questions here. I'm not seeing anything come up, but we could have some very slow typists. So let's.
Okay, it's blowing people away with my knowledge over here. I know.
You are just absolutely blowing me away. All right, so let's have a chat, you and I, because I'm going to go back to what I found to be interesting, which was this time is of the essence clause, and I'm trying to wrap my head around some practical things if I am up against an attorney who insists on time is of the essence clause. So what do you think about the idea of me going to Sage Environmental saying, give me something in terms of how long it's going to take you to do the environmental due diligence, assuming a phase 1, assuming a phase 2, and what are we talking about if there's any level of remediation necessary? Could we perhaps as a practical matter present that to the attorney who is used to that time is of the essence clause? Thoughts on
that? Trying to further carve out like exceptions to the time is of the essence, that hey, time is of the essence, yes, but if we're allowed to get a reasonable extension due to let's say we're basing our time frame on the need for a phase 1, and then Sage goes in the basement and finds these formaldehyde jars or something else crazy, and they go, oh, sorry, we're gonna have to do a phase 2. Can we get some sort of, it is more than possible, and I've seen it done where you have a certain date for, let's say, the due diligence, but then boom, if the bank wants X, Y, and Z, it automatically kicks it out to a subsequent date. I see that more frequently when we're talking about vacant land that's being developed, and we're talking about the permitting and approval process, where, hey, if X happens at the municipal level and we have to go to Y, we need this. But if X doesn't happen, we're gonna have to go this other route, and it's gonna take a little bit longer.
Okay, so let's talk about some practicalities. Let's assume that we have an SBA situation. What type of time frames are you suggesting, realistically taking into consideration the COVID issues and staffing issues? We're going to discard our normal 60-day due diligence, 90-day close. Give us the numbers that you think are our minimum that are reasonable under the circumstances.
I mean, if you can get away with it, earmuffs, Steve. If you can get away with it, 90-day contingency is 120-day close. I know that's like the problem with that is it can be a deal breaker. Like your offer might not even get looked at. Therein lies the rub, is that you can be reasonable and realistic as to what is the reality of the situation now, but because this is an evolving situation, if you're on the front end of that, hey guys, this is the new reality. It's now no longer a 60-90, it's a 90-120. If everybody else is coming in with the old numbers and you're the only person with the new numbers, your offer might not even get looked at.
So you're suggesting instead of asking permission up front, beg forgiveness when you come up against your deadlines and hope you can get an extension.
I mean, I'm a lawyer. I would never tell you to bend the truth or do anything like that. I got something in my eye, but.
Well, that's not bending the truth. That's just putting your deadlines in with the prayer that you're going to get the extension if you start butting it against your deadline.
Totally, because what will end up happening is you're going to get to the 5-yard line and the other side, the seller, let's just say you're on the buyer side, the seller side might be getting upset, but you tell them, listen, we need another 2 weeks and we'll close, or you can terminate the deal, we'll get our deposit back, and then you're going to start all over with somebody brand new, and it's going to be another 90 days.
Right.
So yes, that I'm not even saying it's unethical, because it's just the reality of the situation. This just happens all the time, even with the best intentions and the most above board behavior. I mean, this, like I said, the deal that Steve and I were going to do, it probably closed 2 months later than it was supposed to. I had another deal with again, I like the SBA. I'm not trying to throw them under the bus, but over the last summer, it was a restaurant in Newport. We were going to have a Memorial Day summer kickoff for the Chamber of Commerce there. It closed the Thursday before Labor Day. That the entire summer it didn't close. So, and there was a number of reasons for that. It wasn't all just the financing side, but that was, again, kind of a more extreme example. But this is somewhat similar to another thing that just drives me insane is I don't know how much people are seeing this, but informational purposes only inspections. If you ever see this, stop, call me, and we can talk about it on the phone for 10 hours, because I hate it so much. It just drives me insane. And many lawyers disagree with me about this, and they are all wrong, and I am right. If any of you have seen this, it makes no sense. Similarly, Karen, to what we've been alluding to of going to the table and saying, oh, I'm a cash buyer, wink, wink, but I'm going to get a loan at the last minute. Or, hey, I'll tell you what, hey, I'll do a 30-day contingency, 45-day close. And we all know that's not really reasonable. People will come to you and they'll say, I want an informational purposes only inspection. And I always tell people, what does that even mean? Let's just talk through a normal thing. Karen, let's say I'm going to buy your property from you, okay? And I have an inspection contingency or due diligence. I do my due diligence and I go back to you and I go, Karen, I want the roof fixed. I want the septic pumps. I want all this stuff. Or in the implied second half of that sentence is, or else I will terminate, or I will threaten to terminate, right? You can say to me, Adam, fine, I'll do those things you want. You can say, Adam, I will only do X, Y, and Z. I won't do all of it. Or you can say, Adam, go pound sand. Generally speaking, those are your three options, right? I think what most people mean with this, inspections are for informational purposes only, is that the buyer retains their right to terminate, but agrees not to try and renegotiate the contract.
So I can throw out to you that if you go on the RIAR website and you go under Monica, our legal counsel, I think she's put out an opinion to that effect, saying RIAR's interpretation and NAR, I think by extension, NAR's interpretation is that for inspection only means that a buyer retains the right to terminate. But maybe I'm wrong, but that's what I thought I read. That has not been interpreted by any court. So we're perhaps relying on something that hasn't been tested yet.
So assuming, I love Monica, I agree with her interpretation there, okay? If we assume that interpretation is correct, which again, I believe it is, the clause makes no sense. The contract already says that. My example that I just had where I'm buying your property, remember, option 3 was, Adam, go pound sand, I'm not renegotiating the contract. The seller already has the right to say that. So putting that language in the agreement now, at best, interjects, at best, it's redundant. The contract already says
the water.
Right? At worst, it creates the potential for subjectivity, which is the last thing we want. And I've literally had deals go where people are like, no, that's not what I meant at all. Because if think about it, if we take off our realtor lawyer hat for a second, and you're at a cocktail party and your friend is a realtor and they tell you, hey, if I told you that inspections on a property were for informational purposes only.
Fucking internet.
Right? That doesn't sound like you can terminate, does it? Like if somebody just said informational purposes only, it sounds like it's just for informational purposes only. You don't have the right to terminate. So people always then ask me, and I think, I don't know, is Donna Prescott on? I don't know if Donna Prescott's on this. No, she's not. But I had to deal with Donna maybe like a few months ago. And she had a deal where the buyer waived their right to terminate, but still said, I'd still like to do an inspection. I'm going to flip this property. I want to get in there right away and start doing all the work I need to do to get people, either tenants or a new buyer in there, whatever it was going to be. So can we just still get in there? Because we want to get started day one after closing. And I said, wow, Donna, this might be the only time that this informational purposes thing makes sense, because they've actually waived their right to terminate. It truly is informational purposes only. She's like, okay, so we should let them in. I said, no, of course not. We should not let them in. First of all, if they haven't paid you the second half of that deposit, or like the lion's share of it, we usually do a smaller amount with the offer or whatever, than the larger amount with the purchase and sales agreement. If they haven't paid you that second amount, there's no way they're getting in that building. But even if they have, what if they go in there and do all this, do whatever their inspections, and they find some sort of major problem? And then they go, well, to hell with it, we'll walk away from our deposit. But now the cat is out of the bag, that there's some sort of an environmental problem at this property, or structural problem at this property. And now your deal is dead. You're not going to be able to resell the property at that same price. And maybe you have a deposit to retain, but you're probably going to have litigation over it. So I literally had a realtor call me over the weekend on a deal like this, ask me, Adam, I'm friends with him, but I'm on the seller side. He has the buyer, and he goes, Adam, why are you being a jerk? Why won't you let my buyers go in there? They waive their right to terminate. I said, I played that scenario with him. I said, if I let your people do this, they get in there, they discover some sort of major issue, they bail, and now my people can't resell this property. I'm going to get sued for malpractice. I'm not trying to be a jerk. I'm not trying to be rude. We're friends. I'm not trying to cause a problem here, but you got to see it from the other side. So this is why I just hate that phrase, because I feel like even in the very, very narrow subset of times that it might make sense, I still wouldn't use it. But again, just like we've talked about with the time frames, the 60, 90, you might feel the need to say that to get your foot in the door on an offer. Same deal here. People feel the need to use this phrase, informational purposes only inspections, because it's got this, it's like ubiquitous in our industry now, that people are expecting to see it because they want to feel like their seller's not going to get nickeled and dimed, when the seller already can say no to being nickeled and dimed. So I sound like a psycho when I talk about it, but it's because I've seen it go sideways on people. And when it goes sideways, the clients are going to look at you and they're going to look at me and they're going to say, how could you let me sign this? How did you let this happen? How could you let these people into this property? So cautionary tale. So Alice posted a comment. Alice and I have talked about this previously too. And if you have to use that phrase, what Alice is saying is what I would recommend is that you put the caveat language, kind of similar to when Steve was asking the question about the financing contingency commitment. When is it satisfied? Similar to what Alice has put here, is that if you feel like you have to put that in there because the seller is demanding it, because they want to feel like you're not going to nickel and dime them on the buyer's side, put in there, we all agree that never, despite this phrase being in here, the buyer retains their right to terminate the contract. Because in the RIAR standard residential one, there's a line where you waive your right to terminate. We don't have that in our custom commercial purchase and sales agreements. So I would want to purposely highlight it if for some reason we're using this phrase.
So I would just point out, I think this, for informational purposes only, seems to be a peculiarly residential thing only. In my experience, and other people can chime in, I have not seen it. I see standard due diligence paragraphs. They're very broadly written. They cover everything from, every single possible component you possibly could consider, and with a right to termination within specific guidelines. So I think maybe some of this is a little bit more residential. Maybe we would see this in a mixed use property, let's say a small store on the first level with maybe an apartment upstairs. So that might be relevant there.
Yes, I totally agree.
My experience. And Alice did say, Agata said earlier in the residential side to Steve's question, we protect our buyer clients by accompanying a conditional letter with an extension. So again.
Sorry, Greta had wanted me to expand, but I don't type very fast. So the point is, I think it was Melissa Delaney taught a class once. Once you present that commitment letter, it is binding. So you would need to accompany it with an extension until all of the contingencies are more boilerplate. Make sense? But again, I digress. It's for the residential side.
Okay. How about any, do we have more questions? Do we have more questions on any of this? Any topics that you'd like Adam to take a shot at? Well, come on, let's surprise them. Let's ask some really good questions. Anybody have questions? Steve, you're smiling. Can you throw out one? No. All right.
How much does Steve have to pay his kids to get them on this Zoom?
Okay.
Is Paul Toback ever going to get a haircut ever again? Probably not. No, of course not. Look at that. Look at that mop he's got on his head. All right. Who else was on
All right.
here?
So
I
I'm
know.
gonna ask you one question. I mean,
Sure.
anybody that's done residential knows what a horror story it is to get a residential person out. On a commercial lease, my understanding is that it's a very different situation. The defenses that a residential tenant can raise cannot be raised in a commercial setting. How does that impact the time frame for getting out, terminating a commercial lease?
Okay, great question.
Notwithstanding the fact that the courts have shut down, but just generally, how does that impact things?
Okay, great question. So something I can talk to on that. On the residential side, if you look at the Residential Landlord Tenant Act, it's quite large. If you look at the Commercial Landlord Tenant Act, it's quite small. And the general idea there is that on the residential side, the law is taking the assumption that we have a more sophisticated, more financially capable landlord, a less sophisticated, less financially capable tenant. And so they create all these protections for the tenants, right? You can't do last month's rent. It's only first in security, stuff like that. Whereas on the commercial side, it's much shorter because it's generally speaking, unless the landlord and the tenant are going to agree to something completely outrageous, whatever they'll agree to will kind of allow. I mean, within like whatever common sense here, but that's the general idea. So on the residential side, you've generally got 3 ways to evict somebody: non-payment of rent, which is the fastest way, has its own special court procedure. 2 is they're doing something bad aside from not paying rent. They didn't pay the security deposit. They're having loud parties, whatever. And 3, their tenancy is just up, like they're month to month and you're kicking them out, or their year is up, whatever it is. Number 1, the non-payment of rent is a fast track eviction. That's the fastest one you can get, residential or commercial. You get once they're 15 days late, you send them a demand. 5 days later, you can file in court. Okay, and you get in court 9 days after that. So a little longer than a month. A month-ish. You should be in the court for the case. If you win, tenant has 5 days to appeal it, and if they do appeal it, you're going into superior court. So you could be talking about 2 months full boat. But usually at that first stage, when you're at that first court hearing, usually the landlord and the tenant agree to some sort of like, hey, I'll give you an additional week and I'll waive the back rent as long as you move out. Something like that. We usually sign a consent judgment. The second 2 ways the tenant is doing something bad aside from not paying rent, and there's a normal termination of a tenancy, are normal civil cases in the district court. So you have your normal notice time periods. If the tenant doesn't comply with whatever it's a 30-day notice or a 20-day notice, you file in district court, you serve them, and then you can ask for discovery, whatever, and then ultimately you set a trial date, and then you have your whole eviction trial, and then you can have an appeal. But as a result of that, you could, in essence, 1.5 to 2 times as long in the court process. The commercial side is much more of what does the lease say, as opposed to the residential side, which is what does the statute say. So on the commercial side, normally you're looking at the lease and saying, all right, what is it saying here for default provisions as to when I can send what's called a notice to quit, generally speaking, to the tenant. They've done X thing bad. They didn't pay the rent. They didn't pay the net payment that they needed to pay me. They're leaving trash outside, whatever it is. You're going to send them a notice to quit, assuming they don't comply with whatever cure period you have. You're then filing in the courts, which again is at that point is going to be like a normal civil case. So even if it's a non-payment of rent, you don't get that fast-tracked procedure like you would on the residential side. So, and then also on the residential side, there are some additional opportunities to cure. People can, if it's their first time getting an eviction notice, they can literally cure up until the date of the court hearing. They can pay you the back rent, they get one bite at the apple. Commercial, no. It's basically whatever the lease says. But although it's good because you can send these notices faster if your lease says it, you don't have that fast track non-payment of rent eviction. So you hypothetically could be looking at some level of months to fully get somebody out. And if they appeal it, you'd have to then go to superior court, which can, drag things out even further from there. So less than ideal. And as a result, this is why we see lots of these things settled, cash for keys type situation, even in, not in the high level commercial setting where we're talking about tens of thousands of dollars of rent, but on the lower level commercial stuff, or maybe talking about less than $10,000 of back rent, maybe a boutique shop or a mixed use building, something like that. Usually those get settled because the juice isn't worth the squeeze.
So one thing that came about with the pandemic with residential leasing, people have gone to doing month-to-month rentals versus doing yearly because the courts are so backed up with evictions, non-payment, they're not taking. So you actually get fast-tracked for termination of tenancy right now over non-payment. So that's everyone I've talked, because we own rentals, I will only sign month-to-month now, because all these people are stuck with squatters.
Wow. I'm so glad I don't know that.
So again, I think some of these questions are more on the residential
Yeah.
side. So
Yeah,
maybe-
commercial is much more to,
Commercial,
the lease versus residential is much more to the handbook.
Exactly. So does anyone have any questions at this point on the commercial side of transactional litigation and the like that we can pose to Adam? I think that question is a can of worms, Adam, that for a lot of reasons. You're reading
Yeah,
that-
I mean, I personally have never seen that before.
Yeah, and it seems to me there could be all kinds of consumer protection violations.
Yeah,
things
agreed.
like that. So that's a whole seminar in and of itself about
Yeah.
confession of judgment. So maybe we'll leave that alone and not open up that can until we have about an hour to talk about
Yeah,
it.
yeah, yeah.
All right, so any other commercial questions, or do we want to wrap up? Anything else for Adam at this point? All right, well, Adam, thank you very much for stepping in. I know the pressure was on you to not only do your component of this, but Peter's component. And we thank you for your time, and we thank you for coming and speaking to us, and we hope to see you again soon. So
Right. Let's
we'll
do some more let's do some in-person events. Let's go back to Goat Island when it's nice out this summer.
All
I
right.
think,
so
I think that's
just-
the first Rickabore event I went to, was at Goat Island a few years ago.
So just to kind of look ahead, we did talk about that, and we are going to be transitioning over to in-person events. Probably not for our next session, but certainly the one after that. So in terms of looking forward, just to give you all a preview, we are going to be doing a session. Our next expert forum will be with the real experts, and we're going to be talking about the state of commercial real estate in Rhode Island. We're going to be dividing up the state by counties, and we'll be bringing in local experts on each county to tell you what has happened in the last year and what we expect to happen in the upcoming year. So, Jack, was there anything else I needed to address?
Nope, I think you got everything, Karen.
All right. Have a great night, everyone. Thank you so much. Adam, do you want to stay on for a minute?
Sure, thank you.
All right. Thank you. Thank you all.